In 2019, a vehicle that I owned drove into the BP garage forecourt at Stansted Airport, promptly saw that there was nowhere to park, and then duly left. 18 months later, being a registered keeper of said vehicle, which I might add I do not own anymore and haven't done for a long time, I receive a letter from a parking firm saying that I was in breach of their terms and conditions, and I had to pay a parking charge notice, in other words, an invoice for an apparent contract. Knowing the facts as I did, I thought, nope, I'm not having any of this. Got into a protracted argument, and guess what? They took me to court. Hello, everybody. Welcome back to the channel. Hope you're well. Thank you very much for joining me once again. Andy the Gabby Cabby. Good to see you. Thank you very much for your support. Well, I promised you that I would update you on this as and when information came in, really to try and help others have the confidence to deal with it themselves and let you know that all is not lost. And I, of course, refer to this situation of parking. Now, the vehicle in question in 2019 had just gone to Stansted Airport and dropped some passengers off. Then proceeded to the BP garage, which is literally just down the road from the terminal at Stansted, to go and get a drink, the driver to have a pee and everything else, and then leave. Well, on entering that actual forecourt, nowhere to park. So what did the driver do? Leave. Now, Black Belt Barrister does a very good video where he covers the definition of parking. And I leave a link in the description below so you can see that video. And it's very relevant to this case. You know, what defines parking? Anyway, several months go by, and being a registered keeper of the vehicle, I get a letter in the post saying you're in breach of our terms and conditions, and you need to pay a penalty charge notice. And what they did, they gave me a little picture of the vehicle that I was the registered keeper of actually leaving the forecourt, and there was no indication that it was parked at all, just that it had left. And I knew the facts anyway. It had left, but after appeals and back and forward, they were having none of it and decided to file claim against me again as a registered keeper in the county court. Now, it's very important when you get a small claims court paperwork in the post. One of the things you have to do is do what's called an acknowledgement of service. And what that does, it gives you 28 days to deal with it, either admit you've done it and pay up or file a defence. If you don't, you've got 14 days. And then if you don't act on either of those, the other side can file a judgment, and you more than likely owe the money by default. It's so you have to be on your toes there. Anyway, I filed a defence and I filed acknowledgement of service, and all of that went through. I then received an email from the parking firm saying to me that they'd received a copy of my defence from the court, and basically they were going to proceed with the case. And they attached a copy of what's called an N180. In layman's terms, it's a directions questionnaire. And whenever any court action is, gone through, the claimant gets sent one and the defendant gets sent one. And those are basically, what do you want to happen? Where do you want it to happen? As in court venue, with or without a hearing, and all sorts of things. The claimant actually said that the N180 they'd attached have been sent off to the court. Now, you can actually log on, check the status of your case, and lo and behold, when I did this, no sign of that directions questionnaire having been logged on the system. Anyway, I received this email after that point, not too long ago. Without prejudice, save as to costs, we write to you in relation to the above matter. To assist the court in achieving its overriding objective, our client may be prepared to settle this case. I can confirm our client would be agreeable to £300 in full and final settlement of this claim. The current outstanding balance is £353.96. Should you be agreeable to this, please confirm the same within 7 days. Payment could be made to blah, 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 blah. You can see the name of the company that's given me grief right there. Well, I found this highly irregular because there was no indication of any log of any kind of anything getting filed with the court. And I thought, are they trying to pull a fast one? Now, I fully intend to defend this claim and go to court if necessary because I didn't do anything wrong. And, the driver of the vehicle at the time certainly didn't do anything wrong. This is a scam as far as I'm concerned. So what did I do? I phoned the court. I explained the situation to them and said, what's going on? Because I've got a suspicion they're trying to pull a fast one. The court said to me that because they hadn't heard from the claimant as to their intentions, then what has happened, the claim has been stayed, which means effectively it's been put to one side because they hadn't heard anything. And when a claim has a stay on it, you have to apply to get that stay lifted at a cost of £108 for, in this particular case. I don't know whether that's a fixed fee or it may vary. So when they're trying to get 300 quid out of me and then they've allowed a claim to be stayed and then they've got to pay an additional £108 on top to get that stay lifted and proceed, you've got to think, and based on the flaky evidence that they presented me with, is it worth their time? So have I won? That's what I'd like to know. Anyway, I sent this. Isabella, that was the name of the person that emailed me. I referred to the below email and those received previously. Having just had a conversation with the court, I've had it confirmed that this claim you have made against me was stayed on the 9th of October. Therefore, no other action will proceed unless you pay to the court a fee of £108, which I'm sure you're aware of. Your previous 2 emails sent can only be construed as an attempt to deceive / extort money from me on that basis. My filed defence that you received stands, and any further attempt to communicate with me will be deemed as undue harassment and therefore treated as such. I will not communicate with you any further and take my direction only from the court. I trust my position is clear. Regards. So as soon as I sent that off, I went and sought what you would term independent legal advice, and I was told that if a stay has been put in place and they attempt to lift it, they have to explain how they left it so long and let it get in that situation in the first place. And, the chances of it proceeding are very slim. But we will see, and I will obviously update you again if the need arises. But the moral of the story is don't give up. Just because you get court papers, there are ways of dealing with it. Don't be intimidated. Don't be frightened. Do your homework. Do your research. Put a defence in if you're correct, and you will win the day. Thank you very much. That's the end of this video. Don't forget to subscribe if you haven't done so already. Hit the like button because it helps. Leave comments. Share the content. And again, thank you very much for the support. Andy the Gabby Cabby. I'll see you soon with one more. Toodaloo.